Just waiting on the all clear. All right, everyone. So now that we're here and we just received an all clear, we can get started. So let's call the case of State of West Carolina v. Timothy Ray. My name is Judge Adio. If that's difficult to pronounce, you can just call me Judge A. That's fine. Scoring judges, please look to the two buttons on the lower left of your screen and turn off both your audio and your video if you're a juror. These should remain off until trial ends. You should also have your video set to hide all non-video participants. This means the only people on the screen right now should be the advocates and myself. All right, now, can the attorneys please make their appearances for the record?
Yes, Your Honor. Good afternoon. Can you hear me?
Yes, I can.
Zoe Phelps and Ryan Golden on behalf of the state of West Carolina.
Defense?
Good morning, Your Honor. Can you hear me as well?
Yes, I can.
Myself, Austin Richards, and Ms. Kylie Oblisk represent the defendant in this case, Mr. Timothy Ray.
All right, are there any motions in this case?
Yes, Your Honor. The state does have one motion to exclude. We also have a few housekeeping matters. Would Your Honor like to hear the motion first?
Yes, please.
Yes, Your Honor. As you are well aware, this is a murder case of a 6-year-old boy, Nathan Ray. And in this case, Detective Booth, the state's primary fact witness, he conducted the interview interrogation of the defendant the night of his arrest. And on page 44 of the record, this is found on lines 29 through 30. And we moved to exclude statements by Detective Booth where he says, quote, "You're a piece of shit and he'd be better off dead." And we moved to exclude these under 402 and 403.
Defense, any response?
Your Honor, we have no objection to this redaction.
All right, so then state your motion in limine is granted. Any other additional motions for the state, or can we move on for the defense?
No further motions from the state, Your Honor.
All right, defense, let me hear your motions in limine, please.
Good morning, Your Honor.
Good morning.
This case is about the tragic consequences of untreated and undiagnosed mental illness. No one here disputes that killing Nathan Ray was wrong. No one disputes that Nathan Ray is dead. The only question here today is whether Timothy Ray, his father, was insane. And to answer that question, we need to look at Mr. Ray's mental state at the time of the killing. Your Honor, there's a photograph of Nathan Ray coloring with his crayons and smiling up at the camera, and the prosecution intends to introduce this photograph here today. But this photograph should be excluded under Federal Rule of Evidence 403 because its probative value substantially outweighs is substantially outweighed by a risk of unfair prejudice to the jury. And for Your Honor's reference, this photograph can be found on page 106 of your evidence packet. This photo really carries no probative value. The only reason it could be used for legitimate purposes would be to show Nathan Ray's identity, but parties agree that Nathan is dead. His identity is not at issue in this case. And the only reason that this photograph would be introduced would be for the improper purpose of inflaming the passions of the jury. And because of the sensitive nature of this case, it's extraordinarily important that the jury remain focused on the only question at issue here today, which is whether Timothy Ray was insane.
Before I have the state address that motion, there was a comment from the jurors requesting that Ryan Golden and Zoe Phelps somehow, if possible, step closer to the camera. If you need a minute to do so, please let me know. We'll pause and take that minute so that you can move closer before you respond.
Is that better?
Yes, that's perfect for you, Ms. Phelps. Thank you.
Thank you.
All right, Ms. Golden, I see you shifting.
Is it better?
Jurors, is this okay? I think it's pretty good, Ms. Golden. I think you're all right.
Okay.
That works fine for me.
Okay, perfect. So state, how do you respond to the defendant's motion to exclude Exhibit 29 based on its prejudicial value?
Yes, Your Honor. First, I'd just like to mention that while the defense may not be contesting identity, the state still has the burden beyond a reasonable doubt to prove identity, whether or not they're contesting it. And so this is an extremely relevant picture. I mean, this is why we're here today, Your Honor. And quite frankly, under 403, it'd be a bit absurd to say that the jury can't see a picture of the murder victim as he was on October 17th before the incident.
I'm inclined to agree, so I'm going to deny the defense's motion. The state will be allowed to admit and publish as you see fit Exhibit 29, the photo of the victim. Any other motions from the defense?
Yes, we have one further substantive motion, Your Honor. The prosecution also intends to introduce 2 screenshots from Timothy Ray's cell phone here today. The first screenshot identifies Timothy Ray as the owner of the cell phone. The second screenshot demonstrates or reveals 3 Google searches relating to extradition and disposal of a body. And these screenshots come from Mr. Ray's cell phone 24 hours after Nathan Ray's death. You can find these on page 57, I believe, of your evidence packet. These screenshots should be excluded under Federal Rule of Evidence 402 because they are not relevant. The prosecution will use these screenshots to show that Mr. Ray was sane and that he understood that what he was doing was wrong. But this was 24 hours after Nathan was killed. And the definition of legal insanity requires looking at Mr. Ray's mental state at the time of the killing. And the nature of insanity is that it's not stable or steady. People have psychotic episodes. You can have a psychotic episode and suffer from delusions, and it's like in a small fit, and it can be followed by moments of relative clarity or lucidity. And so showing what his mental state was 24 hours after the killing is not relevant to show what his mental state was at the time of the killing. And therefore it should be excluded under Federal Rule of Evidence 402.
State, any response?
Yes, Your Honor. These Google searches are extremely relevant and probative to whether the defendant's second prong of their insanity defense is that the defendant's mental illness was so severe, that he didn't know right from wrong. And so this is the only circumstantial evidence the state has of disproving that, rebutting that evidence.
So if I understand you correctly, you're saying the only way to rebut the defense's theory of the case is through these Google searches. Is that correct?
No, Your Honor. Sorry if I misspoke. It's the only circumstantial evidence we have to rebut the second prong of their insanity defense, which is whether or not he knew right from wrong at the time. And while they're correct in that these weren't from that instance on October 17th, I mean, these Google searches were done 24 hours after, and that's certainly circumstantial evidence of whether he knew right or wrong at the time.
I am going to reserve ruling on this motion in limine. I'm going to see how the case proceeds because just taking a look at this exhibit, I do have some concern about the possibility of laying sufficient foundation to admit this exhibit, let alone its relevancy. So let's see how it comes out. Please, at that time, before it is introduced, re-raise your motion defense, and then we can revisit it at that time. Any other motions?
No more substantive motions, Your Honor, but we do have some preliminary matters to address when Your Honor is ready.
Yes, I'm ready. Go ahead, defense.
Yes, Your Honor. First, we ask that Dr. Riley not be sequestered in today's trial pursuant to Rule 615C, as he is an advisory witness for the defense.
Any objection from the state?
No objection, Your Honor.
All right, so Riley will not be sequestered. State, would you also prefer that your expert, Dr. LaGreca, remain in the courtroom to hear the testimony today?
Yes, please, Your Honor.
All right, so neither expert will be sequestered.
Next, Your Honor, given the motions in limine that we just discussed, it seems like the court has a copy of the electronic case packet for this case. We just wanted to make sure, and we could provide a courtesy copy if needed.
Oh, yes, I have both a paper and electronic just in case my computer's on the fritz. And so, yes, I have that in front of me. I also believe the jurors will have an electronic notebook in front of them when you publish exhibits. So, yes.
Great, Your Honor. We have two further preliminary matters. The first of which is that the prosecution and defense met prior to today's trial and have both stipulated in its entirety to the jury instructions regarding the insanity defense and both elements. Both parties agree that those elements are in fact accurate.
All right. So if the parties have stipulated to, as much, then that is fine.
And last but not least, Your Honor, may we assume that all evidentiary arguments concerning objections are heard outside the presence of the jury?
Yes, that's fine.
With that, the defense is ready to proceed to opening statements.
State, do you have any housekeeping matters?
Yes, Your Honor, we do. First, when we share exhibits, you may have already addressed this, but when we share exhibits with the witnesses, would you like us to just refer to the virtual notebook, or we can also screen share them on Zoom?
I'd prefer for you to refer to the virtual notebook at the point that the exhibit is admitted. You then may publish it on the screen or however you see fit.
Okay, great. And then second, would the court prefer that we tender our experts pre-trial or during the direct examinations of those experts?
Please tender your expert during the trial.
Third, would you prefer our fact witness, Detective Booth, who is going to identify the defendant today, would you prefer he do so as if we were in person in court, or would you prefer he do so as if we were on Zoom?
I prefer for this to feel as real as possible despite our limitations. So refer to the defendant as you seek, as if we were actually present in a courtroom today.
Okay, Your Honor. And finally, this state would like to invoke the rule of sequestration.
Yes. So I believe it's Detective Booth and Officer Wentz will be sequestered until it's their time to give testimony, at which point they can then enter the Zoom and prepare to give their testimony.
Yes, Your Honor. And finally, we would also like to pre-admit Exhibit 6, which is the autopsy report. It is stipulated to be admissible with no objections. And we spoke about this with opposing counsel prior to this trial.
So defense, you stipulated to this being admitted at this point, correct?
We did, Your Honor.
All right, so Exhibit 6 will be admitted at this stage.
That would be it from the state, Your Honor.
All right, any other matters we must tend to before we proceed to opening statements?
No, Your Honor.
All right, so we will now hear opening statements from each party. Everyone should make sure that they are in speaker view. So if you haven't done so, please take a moment to do so now. That button is in the upper right corner of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. And as for opening statements, it should only be the two advocates who are actually delivering an opening statement who need to have their camera on at this time. Okay, so now, wait, I only see, actually, Mr. Richards, you can keep your camera on. Are you giving the opening statement?
Yes, I am, Your Honor.
Yes, so just make sure you mute yourself, Mr. Richards, until it is your turn. And Ms. Golden, you may proceed whenever you are ready.
Thank you, Your Honor. May it please the court, counsel, members of the jury. The case you will hear today is about a man claiming to have lost his grip on reality when really he just lost his temper. On October 17, 2018, the defendant, Timothy Ray, strangled and killed his 6-year-old son, Nathan, after Nathan spilled apple juice on the defendant's laptop. The morning of Nathan's murder, Nathan was eating a bowl of his favorite cereal, Frosted Flakes. And he was at his dad's house because, you see, Nathan's parents had recently separated, and so they were splitting their time with Nathan. The breakup had been rough, and Nathan's parents were not on good terms. In fact, Jessica Ray, Nathan's mom, had told the defendant, Timothy Ray, just 3 days earlier that she planned on filing for divorce. Now, on the morning of October 17th, Nathan was eating his breakfast when he reached for his glass of apple juice. When he reached for the glass, he accidentally knocked it over, spilling the juice on his father's work laptop and ruining it. When the defendant saw that his laptop had been ruined, he immediately flew into a rage. He'd already been feeling stressed that morning about work, and now this. He chased his son into the other room,
and he forced him to do physical exercises as punishment. He forced Nathan to do jumping jacks and high knees. All the while, the defendant screamed at Nathan. Because Nathan was only 6, he was crying uncontrollably from the sight and the sound of his own father screaming at him. And somehow, the sight of his only son's tears only made the defendant angrier. And when Nathan, exhausted, just couldn't do the exercises any longer, the defendant got even angrier that Nathan wouldn't do what the defendant wanted. The defendant went to his room and he sat on his bed. But instead of calming down, the defendant grabbed a belt. He took the belt and he returned to his son. He hit Nathan with that belt. He hit Nathan with the belt again and again. Nathan cried from the pain of being hit by that belt. Nathan cried out for his mother, and through his sobs, he told the defendant, "I hate you." By now, the defendant was furious. He took that belt that he had just used to beat his son, and he placed that belt around his 6-year-old child's neck. He tightened the belt, preventing Nathan from breathing. The defendant then pulled on that belt until Nathan stopped crying. He pulled on the belt until Nathan stopped moving. He pulled on the belt until Nathan stopped breathing for good. Imagine the horror of that scene. A 6-year-old child with a belt around his neck, struggling desperately, trying to get free, clawing at his neck, kicking, flailing, trying anything he could to loosen the belt, to get his own father to let him breathe. A child's face turning purple and then blue and then white as the life slowly drained from his body. After the defendant killed Nathan, he took Nathan's body and he put it in his car and drove away from home. The defendant stayed in that car for almost 3 whole days, awake. And at some point, he took his son's lifeless body and put it in a black trash bag. He took it to Brandywine State Park. There, the defendant dumped Nathan's body in a shallow grave. He left Nathan alone in the woods to rot. The day after Nathan's murder, his mother, Jessica Ray, went to pick her son up from school as planned, only to learn that he wasn't there. And after the defendant didn't answer her phone calls, she filed a missing persons report. Another day passed. On October 19th, 2018, 2 days after Nathan's murder, the defendant was stopped at a DUI sobriety checkpoint. When officers ran his license, they saw the missing persons report and they arrested the defendant. The defendant was then taken to the police station where he was interviewed by Detective Blake Booth. And in that interview, the defendant confessed to beating his son with that belt. He confessed to strangling his son with the same belt. And he confessed to hiding Nathan's body in Brandywine State Park. Skelton police eventually were able to locate Nathan's body in that shallow grave. That day, Detective Booth had to make a phone call that no one wants to make. He had to call Nathan's mom, Jessica, and tell her that her son, her only child, was no longer missing, but was found dead. And that her ex, Nathan's own father, was the one who killed him. The state has charged Timothy Ray with the murder of Nathan Ray. We have the burden of proving that to you beyond a reasonable doubt. Beyond a reasonable doubt is a high burden for good reason. You have an important job here today, ladies and gentlemen, one that's not to be taken lightly. The evidence you will hear today will convince you beyond a reasonable doubt that the defendant is guilty of Nathan's murder. How are we going to prove that to you? One way is through the defendant's own words when he confessed to police that he had strangled Nathan with a belt. But we're not going to ask you to just take his word for it. We're going to bring you not just what the defendant says, but what the evidence supports. So besides the defendant's confession, you'll also see all the evidence that the detectives were able to find to corroborate exactly how this crime occurred. The other way is through the defendant's own actions on October 17, 2018. That moment of reflection when the defendant sat on his bed in the moments before killing Nathan. The way the defendant killed Nathan by strangling him over the course of minutes, not moments, not seconds, minutes. This evidence will prove to you the defendant is guilty of murder. However, the defendant claims that he cannot be guilty of murder because he was insane at the time he killed his son. Insanity has a legal definition, and at the end of this trial, the judge will instruct you exactly what that means. But the defendant has the burden of proving that defense to you by clear and convincing evidence. Clear and convincing evidence is not as high of a burden as beyond a reasonable doubt, but it's still a really high burden. It's the same burden the state has to carry in order to take your children away. Now, I anticipate the defendant's counsel will get up here in a few moments and will tell you all about the defendant's supposed lifelong struggle with mental illness. After the defendant was arrested, his counsel hired a psychiatrist to evaluate him, and that doctor diagnosed him with schizophrenia. But I want you to pay attention to the timing of these claims. After the defendant was charged with his son's murder, the defendant claims that he was having delusions, that he was experiencing hallucinations, and that he was hearing voices. The evidence you'll hear to support these claims comes almost exclusively from the defendant's own mouth. And if you go back further, you'll see from the evidence that the first time that these claims are being made is only after the defendant strangled his son, only after the defendant was charged with murder, after the defendant had a motive to be mentally ill to avoid responsibility for his crime. Even if the defendant has schizophrenia, having a mental illness alone is not sufficient to meet the definition of insanity. The critical piece is that the mental illness be so severe that it makes the person unable to understand the morally right from the morally wrong. Members of the jury, there's a difference between being unable to understand right from wrong and being unable to simply control your own temper. The evidence will show you that the defendant understood the wrongfulness of his actions on October 17, 2018. The evidence will show you all of the steps the defendant took to cover up what he had done to Nathan in the moments and days after he strangled his son. Timothy Ray did something the rest of us can't comprehend, but it doesn't mean he was legally insane. And at the end of this trial, after you've heard all the evidence, we will be asking you to find the defendant guilty of murdering Nathan Ray. Timothy Ray claims to have lost his grip on reality, but really, he just lost his temper, and Nathan Ray lost his life because of that. We look forward to presenting our case to you.
Thank you, Ms. Golden. Mr. Richards, you may proceed with opening statement when you're ready.
Timothy Ray isn't just a troubled man or someone who struggles with everyday stress, anxiety, or depression. Timothy Ray suffers from severe schizophrenia, including delusions, hallucinations, and negative symptoms. On October 17, 2018, Mr. Ray and his wife were separated, but it was his week to spend time with Nathan. While Mr. Ray was getting ready for work, Nathan was eating a bowl of his favorite cereal and drinking a cup of apple juice. And while Mr. Ray was getting ready for work, he heard a loud clink coming from in the kitchen. So he went into the kitchen and found that Nathan had spilled his cup of juice all over his work laptop. He tries to dry it off, he tries to power it on, but nothing works. It was fried. But then something odd happened. Something erupted inside of Mr. Ray. Voices telling him that he needed to punish his son because his wife had tricked his son into spilling juice on the laptop. So Mr. Ray started yelling at Nathan and forcing him to do exercises like jumping jacks and high knees. But no matter how hard Mr. Ray yelled, no matter how many exercises he made his son do, the voices would not stop. The voices kept getting louder, so he went to his room, grabbed a belt, and started hitting Nathan with it. Nathan started crying and said that he hated his father and stopped doing the exercises. Enraged, the voices kept getting louder. They said, "Punish him, make him understand that she cannot trick him into sabotaging me." So Mr. Ray decides to wrap the belt around his neck and pull until everything stopped. Your Honor, members of the jury, we're not here today to tell you that Nathan Ray is not dead. We're not here to tell you that it was not a tragedy what happened to him. Nathan Ray's death is something that his father will have to live with for the rest of his life. But the reason we're here today is because the law doesn't hold people responsible for what's outside of their control. In this case, the defense has raised an affirmative defense of insanity, meaning if we prove to you two elements by clear and convincing evidence, first, that Mr. Ray suffers from a severe mental disease or defect, and second, that as a result of that defect, he was either unable to appreciate his actions, meaning that he did not know what he was doing, or alternatively, know that what he was doing was wrong, Mr. Ray cannot be held responsible for killing his son. Now, you're going to hear evidence today from Dr. Shane Riley, a forensic psychiatrist who's seen tens of thousands of patients in his career. Dr. Riley diagnosed Mr. Ray with severe schizophrenia, and Dr. Riley will walk you through exactly how he came to that diagnosis. Unlike Dr. LaGreca in this case, Dr. Riley actually interviewed clinically Mr. Ray and reviewed all of the materials associated with the Skelton Police Department's investigation in this case. Now, you heard the state today come up here and tell you that Mr. Ray just lost his temper and that he really doesn't suffer from severe schizophrenia. So let's take a look at Mr. Ray's symptoms before and after Nathan Ray was even born. I want to take you back to 1996. You'll hear evidence that Mr. Ray's been hearing these voices since he was 10 years old. But it wasn't just these auditory hallucinations that Mr. Ray was suffering from. You'll hear that he had started hearing the voices first when he was about 10 years old, but he didn't tell anyone about them because he didn't want to be labeled mentally ill like his mother was. So fast forward to 2012. This is where Mr. Ray starts to lose his ability to control his emotions. He starts erupting into fits where he's crying hysterically, and it was never ending. You're going to hear testimony that Dr. Giuseppe, his family doctor, noted Mr. Ray having one of these episodes in her office in 2012. And moving on into 2014 and 2015, this is when the extreme paranoia started to set in. Mr. Ray started experiencing delusions where he started seeing shapes on walls that would change color and change form over time. And eventually, he lost the ability to take care of himself. Dr. Giuseppe noted that Mr. Ray looked disheveled in a session that she had had with him between 2017 and 2018, where it looked like he hadn't bathed in weeks. And moving forward into 2018, the voices came back. And the voices this time were stronger than ever. They were telling Mr. Ray to harm people. And moving into October 17th of 2018, Mr. Ray heard voices that were telling him to hurt his son because his wife tricked him. Even after the fact, Mr. Ray started having delusions where he thought that the CIA was after him because he was a terrorist. And even people that he knew, like Detective Blake Booth and Dr. Giuseppe, and even Dr. Shane Riley, he thought were government agents, were members of the CIA that were out to get him. This isn't somebody who just lost his temper. These are severe mental issues that Mr. Ray has been experiencing long before Nathan was even born. And we're not here to make an excuse for Mr. Ray or say that what happened on October 17th wasn't a tragedy. We're here today to ask you to follow the law. And because Mr. Ray didn't know what he was doing on October 17th was wrong, the law doesn't hold him responsible for it. Find Timothy Ray not guilty by reason of insanity.
Thank you, Mr. Richards. State, call your first witness.
Yes, Your Honor. The state calls Detective Blake Booth to the stand.
Good afternoon, Detective Blake Booth. We will assume that you are constructively sworn in since I am missing a bailiff. You may proceed when you're ready, State.
Good afternoon, Detective. Could you please turn to the jury and tell them your name?
Yes, I am Detective Blake Booth.
Detective, what do you do for work?
I work for the Skelton Police Department as a detective in the Homicide Division.
How long in total have you worked for the Skelton Police Department?
Over 20 years. I think it's almost to 25 now.
Of those years, how long have you been a detective?
I have been a detective for about 10 years now.
Detective, I'd like to talk to you about your involvement in this case. What was your role in this case?
I was the lead detective on the missing persons case for Nathan Ray.
Who was Nathan Ray?
Nathan Ray was a 6-year-old boy, and I was assigned to his case.
Detective, you have a copy of the virtual exhibits, don't you?
Yes, I do.
I'd like to show you exhibit 29, if you could view that, please.
Okay.
Do you recognize this?
Yes, I do.
What is it?
This is a photograph of Nathan Ray.
Who gave you this photo?
Nathan's mother, Jessica, gave this to me when his missing persons case was first opened.
Is it a fair and accurate depiction of Nathan as he appeared before October 17th, 2018?
Yes, ma'am, it is.
Your Honor, at this time, the state offers exhibit 29 as evidence.
Based on my ruling in the prior motion in limine, that will be granted. Please proceed to publish the exhibit.
Thank you. My co-counsel will be sharing screen to show the jury the exhibits, if that's okay.
Granted, that's fine.
Thank you. Detective, you said this case started as a missing persons case. Who was your main suspect?
My main suspect in this case was Nathan's dad, Timothy Ray.
Why was that?
Well, typically, when this case was first opened, his mother, Jessica, had mentioned that there had been some marital troubles. Typically, in a missing persons case involving a child, especially if there have been marital troubles, we usually start with the parents.
How were you able to come into contact with Timothy Ray?
I was at my house around 9 o'clock on October 19th. I received a call that he had been pulled over at a sobriety checkpoint, and his name had popped up when they ran his license and registration in Nathan's missing persons case. So I had them take Mr. Ray back to the station after shutting down the sobriety checkpoint.
Once the defendant was taken back to the station, were you able to interview him?
Yes, ma'am, I was.
What did he tell you in that interview?
He confessed to strangling his son with a belt and then burying his body in Brandywine State Park.
Detective, had you met the defendant before this interview?
Yes, ma'am, I had.
What were the circumstances of that?
Our children played on the same soccer team, so I would see him at the games. I tried to talk to him here and there. He wasn't very social, and we couldn't carry on a conversation. That was the extent of our interaction.
Was there anything about this previous interaction that affected your investigation in this case?
No, ma'am.
Now, Detective, is the man that you interviewed on October 19th in the courtroom here today?
Yes, ma'am, he is.
Would you please identify him by his location in the courtroom and an article of clothing?
Yes, he is sitting at the table next to his attorneys, the defendant's attorneys. He's wearing an orange jumpsuit with handcuffs.
Your Honor, may the record reflect that the detective has identified the defendant in open court?
The record shall so reflect that in court identification.
Now, Detective, let's talk a little bit about your interaction with the defendant on October 19, 2018. What was your perception of the defendant's emotional state during that interview?
Objection, Your Honor. Improper lay opinion. I can expound further if needed.
Yes, please do.
Your Honor, I believe the witness is being asked to testify as to specialized knowledge that only somebody in the field of psychiatry or mental health would be able to elicit. There's been no foundation laid that Detective Booth has any expertise or experience or knowledge about dealing with mental health issues. Therefore, we believe he should be precluded from anything that would go beyond his rationally based perception.
Response.
Yes, Your Honor. All I'm asking the detective to testify to is what he perceived from the defendant's behavior, what the defendant's emotional behavior was like. I'm not asking the detective to opine on any mental illness, just on what he perceived based on the defendant's actions during the interview.
So just to be clear, this witness is not going to testify to any medical terms or use any medical jargon to describe the defendant's state of mind at that time, correct?
No, Your Honor.
All right, your objection is overruled. You may
May
proceed.
I have a clarification on the court's ruling, Your Honor?
Sure, Mr. Richards.
Does that include observations that the defendant seemed normal and that he wasn't exhibiting any other symptoms?
If the state can lay sufficient foundation that this witness perceived certain actions that led him to conclude that he didn't seem normal to him, that will be permitted. However, if this witness is going to expound that he appeared to be and use any medical terms to describe that, then that will not be permitted. Does everyone understand my instruction?
Yes, Your Honor.
All right.
Yes, Your Honor, thank you.
No problem. That objection is overruled. You may continue.
Detective, would you like me to repeat the question?
Yes, please.
During your interview with the defendant, what was your perception of the defendant's emotional state?
You know, he was very somber throughout the interview. He was crying a little bit here and there, but yeah, just somber and crying.
Besides his emotional state, what was the defendant's behavior like during your interview?
Other than that, nothing seemed out of the ordinary to me.
Did he respond to your questions?
Yes, ma'am, he did.
Was there anyone else in the room during the interview?
No, it was just the two of us.
And who did the defendant speak to during the interview?
He spoke to me.
Was there anything about this interaction that made you think that he didn't understand what was going on?
No, ma'am.
Detective, did the defendant say anything strange to you during the interview?
There were a couple of times where he asked me if I was in the CIA, things like that. I had learned from the officer who was running the checkpoint that he started asking those questions a little while after he had already been reasonably responding to the officer's questions. So it seemed to be a continuation of what.
Objection to lack of foundation.
Yeah, so I just heard this witness testify that he had learned that the defendant was asking about the CIA at a checkpoint. Did I get that testimony correct? Sorry, I don't have a court reporter. Is that right, Mr. Booth?
Yes, Your Honor, that's correct.
Okay, so counsel, can you lay some foundation as to how he learned that information? Because just based on that statement, I have no idea the who, what, when, where in regard to how he gained that information. So your objection is sustained.
Sure, Your Honor. Detective, you mentioned earlier in your testimony that the defendant was pulled over at a sobriety checkpoint, and you were informed of that. What did you do when you were informed of that fact?
I briefly.
Objection is to hearsay and lack of foundation, Your Honor. I don't think that serves as adequate foundation for the opinion.
Yeah, I'm inclined to agree in terms of foundation. Counsel, I need to know who informed him at what time. I understand the location was the sobriety checkpoint, but we just need a little bit more. In terms of hearsay, counsel, what do you have to say?
Yes, Your Honor, I can move on. I can move on. This is not something that intrinsic to the state's case. I'm happy to move on.
All right, so defense, both of your objections are sustained. Proceed, counsel.
Detective, from during your 25 or so years on the force, have you come into contact with people who are mentally ill before?
Yes, I have.
Did any of those previous interactions come to mind when you interacted with the defendant?
No, ma'am, I did not.
From your previous interactions with the defendant socially at your children's soccer games, did you ever form an opinion that the defendant was mentally ill?
Objection leading.
Sustained.
During your previous interactions with the defendant, what was your opinion on the defendant's mental state?
He seemed to be, fairly normal, definitely very introverted, not very social.
What about your opinion changed throughout your investigation in this case?
My opinion of the defendant did not change throughout the investigation.
Detective, I'd like to talk some more about your investigation. After you interviewed the defendant, what did you do?
After we interviewed the defendant, I put together a team to go out to Brandywine State Park to check to see if we could find Nathan's body, and then we also searched for additional evidence.
Were you able to find Nathan's body?
Yes, we were.
Where was it?
It was in Brandywine State Park, as the defendant told me.
What other evidence, did you find any other evidence that corroborated what the defendant told you in the interview?
Yes, ma'am, we did.
Where did you find that evidence?
We found that evidence both at the defendant's house and then in the back seat of his car.
Did you photograph or collect these items of evidence?
Yes, ma'am.
Would you recognize a photograph of the evidence you found if I showed it to you today?
Yes, I would.
Detective, if you could turn in your digital notebook of the exhibits to Exhibit 10 and Exhibits 18 through 28. Do you recognize these?
Yes, ma'am, I recognize all of those.
And what are they generally?
Counsel, not to interrupt, but just for the sake of ease for the court and the jury, could you just refer to page numbers as well, if possible?
Yes, if I can grab my packet. I don't have the page numbers written down, just the exhibit.
Actually, no, then continue. I don't want to stop you, but
Okay.
if everyone else could, that would be fantastic. Thank you.
Thank you. What's depicted in these exhibits generally?
So these are all of the pieces of evidence that we found throughout our investigation.
Are these pictures fair and accurate depiction of all the evidence you photographed and collected during your investigation?
Yes, ma'am, they are.
Your Honor, at this time, the state offers Exhibit 10 and Exhibit 18 through 28. Exhibit 10 is the subject of your prior motion in limine.
Any objection, defense?
Yes, Your Honor, we would renew our objection during the motion in limine and also add an objection to lack of foundation.
And is that just for Exhibit 10, or do you have an objection as well for Exhibits 22 through, what number do you have through 26, you said, counsel?
28.
28, my apologies.
One moment, Your Honor, that's a lot of exhibits.
Understood.
Yes, so we would limit our objections to just Exhibit 10. And I can expound further on the lack of foundation objection if needed.
Yes, please do so.
No foundation has been laid beyond the fact that the police searched this phone and found it in the defendant's house. We don't know who made these searches, and the foundation can't be laid through this witness. And furthermore, as per the ruling regarding the motion in limine, we would argue that because this happened a whole day after the fact, and schizophrenia can appear in episodes where symptoms can come and go for years, the admission of this evidence, its probative value would be substantially outweighed by the risk of unfair prejudice.
As in regard to your relevance objection, I do believe that Exhibit 10 is relevant. And so for that reason, I do believe it's relevant. However, lack of foundation is still at issue. Counsel for the state, will you be able to establish who made these searches?
Your Honor, we were able to establish that the detective found the phone at the defendant's house, I believe, that if you notice on Exhibit 10, it also shows not just a screenshot of the Google searches, but also a screenshot of the ownership of the phone, showing the owner of the phone was named Timothy Ray. We don't have any direct evidence that Timothy Ray is the one who made the searches, but there's also no evidence to indicate there was anyone else available, anyone else around who would have made the searches. The phone was in the defendant's exclusive control. There's no facts to indicate anyone else had access to it.
May I respond on those grounds, Your Honor?
No problem.
The cell phone and the searches that were made weren't even found with the defendant. The defendant had already been arrested at this point, and it was found in the defendant's home. And furthermore, we don't think it's sufficient foundation to lay that simply this is Timothy Ray's phone and some searches were made. Therefore, we think this should not be admitted for those purposes.
All right, so in terms of exhibits 22 through 28, those exhibits will be admitted. In terms of exhibit 10, counsel for the state, if you could just lay foundation regarding how, like, if you know who made these searches, then I will be inclined to admit it. Because it seems to me you've explained that you're able to do so. So let's just hear it out of Detective Muth's mouth, okay? So I will sustain it for now.
Yes, Your Honor. Detective Booth, I'd like to start with the evidence you found at the defendant's home first, and then come back to the rest of it. What did you find at the defendant's home?
We found the apple juice that had been spilled on the counter, as well as the belt in Nathan's room, and then we also found the defendant's phone.
Now let's talk about that phone. What indication on the phone did you find about who the owner of the phone was?
Objection leading.
Overruled.
On the settings page, it shows the Apple ID of the individual who's logged into the phone, and it showed that the defendant was the owner of the phone and was logged into his ID.
And without going into the detail, what generally did you find on that phone?
We found 3 searches that were made the day after Nathan had been killed.
Based on your understanding of the case, the information the defendant gave you in his interview, who do you believe made those searches on the phone?
Objection, speculation.
I'm going to overrule your objection. Counsel's question was based on your interview with the defendant, who do you believe? So she's not asking him to jump into the mind of the defendant. It's just based on what his rational belief after talking with the defendant. So
Yes, Your Honor.
After reviewing the searches and hearing what the defendant told me in our interview, I believe that it was the defendant who made these searches. Some of the searches line up with what the other evidence that we found. So I believe it was him.
Your Honor, at this time, the state reoffers Exhibit 10.
Exhibit 10 will be admitted.
Detective, I'd like you, if you could, to read the searches on Exhibit 10 to the jury, please.
Yes, ma'am. Starting from the bottom, it's will bleach destroy a body, how to get rid of a body, and countries that don't extradite for murder charges.
What was the date of those searches?
October 18th.
Now, let's talk about the evidence you found in the defendant's car. What did you find there?
In the back of the defendant's car, we found a shovel, as well as bottles of bleach and some black trash bags.
And what was the significance, if any, about those black trash bags?
The black trash bags look to be substantially similar to the ones that we found Nathan's body buried in.
Let's talk about how you found Nathan's body. You said you found it in Brandywine State Park. What was that scene like?
It was, it's almost indescribable. We found the body stuffed into a black trash bag. You could see the shoes poking out from the top, and it was in the shallowest grave you could imagine. I don't even know if you could call it that. It was barely covered with dirt.
Detective, have you investigated murders before?
Yes, ma'am, I have.
Is it a common occurrence that someone loses their temper and kills another person?
Yes, that can certainly be a case in which we investigate murder.
Does the fact that the person lost their temper mean that they're unable to understand right from wrong?
No, ma'am.
Pass the witness.
All right, Mr. Richards Cross, when you're ready.
Yes, Your Honor. One moment while I set up. May I inquire?
Yes, you may.
Good morning, Detective Booth.
Good morning.
I'd like to begin by talking about your experience as a detective. Now, as you just mentioned, this wasn't your first murder investigation.
No, sir.
In fact, murder investigations are a big responsibility,
Yes, they are.
something that shouldn't be taken lightly.
Absolutely not.
And in a murder investigation, it's important to collect all relevant evidence.
Yes, sir, it is.
One piece of evidence you might collect would be to conduct an interview.
Yes, sir.
And your interviews can be recorded through audio, video, and with a transcript.
Yes, sir.
With a video recording, you can see what somebody's facial expressions are and their body language.
Yes, sir.
And with an audio recording, you can hear someone's voice inflections and what their tone is.
Yes, sir.
As a detective, you're also required to follow directives.
Yes, sir.
One of those directives is that you should record interviews with audio, video, and a transcript when possible.
Yes, sir.
Another directive that you're required to follow requires you to preserve all evidence.
Yes, sir.
And as you mentioned on direct examination, you did conduct an interview with Timothy Ray in this case.
Yes, sir, I did.
In this interview, he supposedly confessed to killing his son.
He did confess.
But you didn't record an audio or video recording of this interview.
No, sir, I had a transcript.
That's right, you had a transcript, but directing you back to my question, you didn't preserve the audio or video from this interview.
No, sir.
And with just a transcript, we can't hear what Mr. Ray's voice inflections were or his tone.
No, sir.
And with only the transcript, we can't see what his body language may have been like.
No, sir, but I can tell you what his body language would have been like.
Now, I'm not asking you what you perceived. I'm just merely asking for the court today, we don't have an audio or video recording for this interview.
No, sir.
And let's talk about the specifics of that interview. During your interview, Mr. Ray asked you if you were with the CIA multiple times.
Yes, sir.
This was odd because you knew Mr. Ray prior to arresting him.
I knew him prior to arresting him. I don't know if it was odd because I knew him prior.
Detective Booth, you're getting a little ahead of me, though. I'm not asking you whether or not you may thought it was odd, but you did know him before this interview.
Yes, sir, I did.
As you mentioned, your sons played soccer together.
Yes.
And at those soccer games, you had several conversations with the defendant.
Yes, sir. I don't know if you could call them conversations, but I certainly tried.
Well, you did speak to him.
Yes.
And in fact, even in this interview, you told him that you weren't a member of the CIA
Yes, that's correct.
and that he knew who you were.
Yes, sir.
Yet Mr. Ray responded by saying, "No, I think you're CIA."
Yes, I believe he said that at one point.
And also throughout the course of this interview, Mr. Ray had told you that his son had spilled some juice on his work laptop,
Yes, sir.
and that his wife had tricked him into doing it.
Yes, I do believe he said that.
And as a result, Mr. Ray told you that he had to punish his son.
Yes, sir, that's right.
But he also told you that he would have never done so if they didn't make him do it.
Yes, he did say that.
But just to be clear, Detective Booth, throughout your whole interview, you never asked who they was.
No, sir, that's correct.
And at the end of the interview, Mr. Ray asked you for help.
Yes, I believe he did.
Because Blake said you would help him.
I'm sorry, do you mean me?
That's exactly my point, Detective Booth. Mr. Ray asked for your help because, in Mr. Ray's words, Blake said you would help him.
I'm not sure I understand. Are you saying that he said that I would help him, as in my first name?
Well, let's break it down, Detective Booth. Mr. Ray asked you for help.
Yes, sir.
And then, after he asked you for help, he said Blake said you would help him.
He said that I said I would help him, if that's what you're asking. I'm getting hung up on the past tense, but he said I said he would help him.
Well, that's it, Detective Booth. He didn't use the word you or I when he said Blake would help him. He used Blake in the third person.
Yes, he used my name.
And just to clarify, Blake is your name.
Yes, sir.
I'd like to finish up by talking to you about a few events that occurred after your interview. As you mentioned on direct examination, you had spoke with Nathan's mother.
Yes, sir.
And you informed Nathan's mother that Nathan was found dead.
Yes, sir.
And Nathan's mother's reaction was, she said, I knew I shouldn't have left Nathan with him when he was acting this way.
Yes, she did say that.
And as you mentioned, you found Nathan's body in Brandywine State Park.
Yes, sir, where he told me it was.
But the body wasn't completely buried.
No, sir, it was not.
In your words, it was a very shallow grave.
Yes, it was.
And the trash bag could be clearly seen.
Yes, that's why we were able to find it.
No further questions.
Thank you, Mr. Richards. State any redirect?
Brief redirect, Your Honor.
You may proceed.
Detective, how long did it take you to find Nathan's body in Brandywine State Park?
I mean, it wasn't right away. The defendant didn't tell us exactly where he had buried it, so we had to look throughout the entire park, but we eventually found it.
Thank you, Your Honor. No further questions.
All right, I don't believe there's any recross, and so Detective Booth, you will be dismissed. Thank you.
Thank you. Your Honor, do I leave the Zoom meeting?
Yes, please leave the Zoom meeting.
Thank you.
All right, State, call your next witness.
Yes, Your Honor, the state calls Dr. McLagreca to the stand.
Good afternoon, Dr. LaGreca. You will be constructively sworn in. State, you may proceed when you are ready.
Thank you, Your Honor. Good afternoon, Dr. LaGreca. Could you just briefly turn to the jury and introduce yourself?
Hello, my name is Dr. McLagreca.
And what do you do for a living?
So I'm a fellowship trained forensic psychiatrist, and I'm also the program director of the Forensic Psychiatry Fellowship at West Carolina School of Medicine.
Let's talk about your education. Where did you go to college?
I went to undergrad at the University of Delaware, where I studied chemistry.
And after that, where did you go to medical school?
I went to med school at Penn.
And could you briefly describe, for those of us who may not know, what the education is required or not required after medical school?
Yeah, so after medical school, any doctor in the whole world has to do a residency where they specialize. So if you want to practice clinical medicine, you pick what specialty you want to go into. I chose to go into psychiatry. So I did a residency in psychiatry where we kind of study all of psychiatry. So inpatient, outpatient, any psychiatric illness you would see. And then after, you can further subspecialize in your specialty to learn more about a specific field of psychiatry.
And where did you do your residency?
So I did my residency at UCLA in general psychiatry.
And after that, what did you do?
And after I returned, where I went to medical school at the University of Pennsylvania and did a forensic psychiatry fellowship.
After finally completing your education, what did you do?
So after that, I opened up my own private practice, and I did that for 23 years.
Could you briefly tell us why you chose forensic psychiatry to devote your career and education to?
Yeah, I've always been very interested in the law. I knew I wanted to be a doctor, but I like the law. And I also really like working with patients who have mental illness. I feel like they always don't have the best advocates, and I think their pathologies are interesting.
Do you have any honors or recognitions?
Yes, so I'm board certified in 3 states, which means I can practice psychiatry in West Carolina, in New Jersey, and Pennsylvania. And I'm also board certified by the American Board of Psychiatry and Neurology.
And do you have any, are you a member of any professional organizations?
Yes, I am. And I actually, in fact, served as the president in 2016 of the American Psychiatric Association.
Lastly, are you being compensated for your time here today?
Yes, I am.
And what were you asked to do in this case, Dr. LaGreca?
So I was asked to review everything in connection with this case and to give my medical opinion on Mr. Timothy Ray and make a diagnosis.
What materials did you review?
I reviewed everything in the joint exhibits list, including Dr. Riley's most recent clinical evaluation of the patient.
Were you able to interview the defendant in person?
No, I was not able to interview the defendant in person.
But in viewing everything you just mentioned, were you able to come to a sufficient factual basis to come to an opinion?
Yes, I was.
And is that the type of evidence that you reviewed that experts in your field generally rely on?
Yes, it is.
And lastly, is your opinion here today based on a reasonable degree of medical certainty?
Yes, it is.
Your Honor, at this time, we tender Dr. LaGreca as an expert in forensic psychiatry.
Any objection?
Yes, Your Honor. We have no objection to Dr. LaGreca's qualifications to testify as a forensic psychiatrist. However, we have a strong objection to one of the methods that she used in coming to her conclusions here today, and we would like to voir dire on that, Your Honor.
Yes, you may be permitted.
May we do so outside the presence of the jury?
Yes, of course.
Certainly, Your Honor. Doctor, let's start with the 2 conclusions that you came to in this case, just so we can understand why the method you used is so important. You concluded that Mr. Ray was not schizophrenic, right?
Correct.
Because he didn't meet the DSM-5 criteria for schizophrenia.
Correct.
But you separately concluded that Mr. Ray was likely malingering.
Yes, I did.
And that just means faking his symptoms, right?
Correct.
Doctor, I want to focus on the methods that you used to arrive at that second conclusion regarding malingering. And I want to make sure we're talking about the same thing here. So I'd like to show you those DSM-5 entries that you relied on in coming to these conclusions.
Okay.
Let's look at what makes the DSM-5 entries for schizophrenia and malingering different. And first, let's review the method that the DSM-5 provides for diagnosing schizophrenia. It lists 5 symptoms of schizophrenia, right?
Correct.
It tells you how many symptoms a patient has to have.
Mm-hmm. Yes.
And it tells you how long they have to have those symptoms.
Yes, it does.
And it tells you that the symptoms have to cause some sort of serious impairment in the person's functioning.
Yes, correct.
Now, when all of these criteria are met, you diagnose someone with schizophrenia.
Correct.
But when any of these criteria is not met, you do not diagnose them with schizophrenia.
Correct.
Now, I want to turn and look at what makes the DSM-5 entry for malingering different.
Okay.
It lists 4 factors for malingering, right?
That is true.
And it says that when some combination of factors is noted, you should strongly consider malingering, right?
Correct.
Thank you, Dr. LaGreca. Your Honor, I'd like to return to our objection. This expert should not be permitted to testify regarding malingering. Pursuant to Federal Rule of Evidence 702C, an expert can only opine based on both reliable principles and methods. We don't dispute that Dr. LaGreca is qualified to testify as a forensic psychiatrist, but we have seen that the DSM-5 does not provide any method for testing for malingering. It's not like the diagnosis criteria that the DSM-5 provides for schizophrenia. And because the DSM-5 doesn't actually provide any method to test for malingering, this expert cannot possibly satisfy the requirements of 702C and should not be permitted to testify on malingering.
State, any response?
Yes, Your Honor. I believe Dr. LaGreca just testified earlier when I was asking her about her education and what she was asked to do in this case, that what she did was she reviewed all the materials in this case and applied what she knew to come to an opinion. And I believe that is enough for reliability here, and that those factors she just needs to consider under malingering. I anticipate when we get to malingering, she'll testify about how she applied them.
Your Honor, may I respond?
Yes, you may.
The schizophrenia entry sets out clear criteria and tells you how to apply the criteria. The malingering entry merely suggests that you consider certain factors, and then even if you consider those factors, it doesn't tell you what to do with them. It just says that you should consider malingering. It's like providing a list of ingredients without giving you directions on how to bake a cake. Different psychiatrists could apply or consider these factors and come out with like cakes or cupcakes or pretzels. There's just no standard way that this is applied, and so it shouldn't be admitted as expert testimony.
Based on that argument, I'm inclined to admit Dr. LaGreca and tender her or allow the tendering of her as an expert. I understand your point, counsel. However, there is the DSM-5 that outlines malingering, and it's my understanding that this is kind of an area of medicine that can be subjective. And so if you believe at that point that opinion is elicited, that not sufficient foundation was laid for her to render that opinion, then feel free to raise your objection. But at this point, I do think this expert has the qualifications and background necessary to be tendered as an expert at this point. So your objection is noted, but it is overruled.
Dr. LaGreca, can you briefly tell us your overall conclusion in this case?
Yeah, so my overall conclusion is that the defendant was malingering and that the defendant did not have schizophrenia.
Malingering, let's talk about that. Could you briefly describe to the jury what malingering is?
Yeah, so malingering is when a patient normally either fakes or exaggerates their symptoms in order to be diagnosed with a mental illness. And usually it's in the context of an obvious reason or an external gain.
And is this something that psychiatrists need to consider?
Yes, it is.
How come?
Well, any mental diagnosis, any psychiatric diagnosis is very serious, and it can be very life-changing for the patients. And we also use very serious drugs to treat them. So we would never want to diagnose someone or treat someone if we aren't sure that that's what they have.
And how do psychiatrists, such as yourself, go about determining if someone is malingering?
So we use the DSM-5 to make the diagnosis.
Your Honor, at this time, may my opposing counsel share a demonstrative that's been previously disclosed to opposing counsel on the DSM-5 malingering criterion?
In defense, did you have any objection to them sharing this demonstrative? All right, then yes, that will be granted. You may publish as you see fit.
Thank you, Your Honor. My co-counsel, Ms. Golden, will be sharing this demonstrative. Ms. Golden, I think your screen is frozen. Going back to the first slide. Ms. Golden, I believe you clicked the first slide and then the start slideshow button on the, thank you. Can you briefly describe, Dr. LaGreca, what the DSM outlines for malingering?
Yeah, so the DSM looks for a couple things. So one thing that we look for is the context of the interview.
Did you find that factor present here?
Yes, the defendant was evaluated by Dr. Riley in the context of these murder charges, and he faces years in prison for this.
Would it be accurate to put a check mark next to this factor?
Yes, it would.
What else do you consider for malingering?
So for malingering, we consider if there's a discrepancy between what the patient claims and the objective findings.
Did you find that present here?
Yes. So during his interview with Dr. Riley, he said Nathan had smashed his personal laptop. However, the objective evidence showed that Nathan spilled juice on his work laptop. So that's a clear discrepancy.
Would it be fair to put a check mark next to this factor?
Yes, it would.
What's something else you look for when determining malingering?
So we look for a lack of cooperation either during our diagnostic evaluation or complying with the treatment that we prescribe.
Did you find that present here?
Yes, so a few times during his interview with Dr. Riley, when pressed on certain subjects, the defendant would lash out and have an angry outburst.
Be fair to put a check mark here?
Yes, it would.
What else do you look for malingering?
So the last thing we can consider is the presence of an antisocial personality disorder.
Did you find that here?
So I can't say for certain if Mr. Ray had or did not have this, but I did not see any evidence for this specific disorder.
And in looking at these factors, how many, if any, are required to find malingering?
I'm pretty sure that I'm not positive how many are required, but based on this, you need at least 3. So I know that the defendant was malingering.
Thank you, Dr. Greca. Now let's move on to schizophrenia. What is schizophrenia?
So schizophrenia is a psychiatric disorder in which people kind of interpret their reality abnormally.
And how do psychiatrists diagnose patients with schizophrenia?
So psychiatrists use all the knowledge we've learned in med school and residency and fellowship also. And then we look at the patient's symptoms, the clinical evaluation, and we kind of compare what we found to the DSM-5 diagnosis.
And could you just remind us what the DSM-5 is?
Yeah, so DSM-5 is kind of the gold standard that all doctors, not even just psychiatrists, use to make any psychiatric diagnosis. It has criteria for each specific diagnosis.
And what's the first criteria under the DSM-5?
So for schizophrenia, there needs to be 5 symptoms, 2 out of the 5 total symptoms.
And how long do those symptoms need to be present for?
They need to be present for 1 month or longer.
Why is there a time period for these symptoms?
So there's a time period because an isolated incident of any of these symptoms would not be indicative of schizophrenia. Schizophrenia is a chronic illness, so just having it for 1 or 2 days could be exacerbated stress or something different. So the time period is to make sure that we're making the correct diagnosis of schizophrenia.
How strict is this 1 month time period?
So it is pretty strict. It's not exactly 1 month because some patients can't say what they were feeling every single day, but we go for kind of most days in a month. So it needs to be longer than an isolated incident. So we look for most days in a month or a month at least.
And what's one symptom you look for in diagnosing schizophrenia?
So something we look for are delusions.
What's another symptom you look for?
We look for hallucinations.
What's another symptom you look for?
We look for disorganized speech.
What else do you look for?
We look for grossly disorganized or catatonic behavior.
Do you look for anything else when diagnosing schizophrenia?
Yes, we also look for negative symptoms.
Do you think it would aid the jury in your testimony if we used these symptoms and applied them to your evaluation of the defendant using a checklist?
Yes, I do.
Now, let's talk about in the first column and everything you reviewed, symptoms that the defendant claimed after his arrest. Did the defendant claim to have delusions after his arrest?
Yes, after his arrest, he did claim that.
Would it be fair to put a check mark there?
Yes, it would.
Did the defendant claim to have any hallucinations after his arrest?
Yes, he claimed hallucinations.
It'd be fair to put a check mark there as well?
Yes.
Did the defendant claim to have any disorganized speech after his arrest?
No, I don't believe so.
Be fair to put an X there.
Yes.
And did the defendant claim to have any grossly disorganized or catatonic behavior after his arrest?
No, I don't believe so.
Be fair to put an X there. And lastly, did the defendant claim any negative symptoms after his arrest?
Yes, he did.
Be fair to put a check mark there.
Yes.
And now moving backwards in time, for everything you reviewed, looking at corroborating evidence of these symptoms from before his arrest, did you find any corroborating evidence of delusions before his arrest?
No, I did not.
Be fair to put an X there.
Yes.
Did you find any corroborating evidence of hallucinations before his arrest?
No, I did not.
Be accurate to put an X there.
Yes.
And did you find any corroborating evidence of disorganized speech before his arrest?
No, I did not.
Be fair to put an X there.
Yes.
Did you find any corroborating evidence of grossly disorganized or catatonic behavior from before his arrest?
No.
Be fair to put an X there.
Yes.
And lastly, was there any corroborating evidence of negative symptoms before his arrest?
Yes, there was. He had a previous diagnosis of generalized anxiety disorder, which includes many negative symptoms.
Be fair to put an X there. I mean, a check there, excuse me.
Yes, I checked there.
And just briefly, could you describe what negative symptoms are?
Yeah, so negative symptoms are kind of, you can picture when someone turns down the volume on you. So you have a depressed mood, you can have changes in your sleep, but a lot of those symptoms can be found in generalized anxiety disorder.
So overall, what again was your opinion of the defendant having schizophrenia?
So my opinion is that the defendant did not have schizophrenia because clearly you can see that he did not have two symptoms for longer than 1 month.
Thank you, Dr. Grega. Thank you, Ms. Golden. You can stop sharing the screen. I'd like to just ask you a couple questions. What are some effects of schizophrenia?
So schizophrenia, it can kind of vary from patient to patient and depending on the severity, but in a psychotic episode or if someone is having severe schizophrenia, they can't really relate with what they're doing to the outside world. So they don't understand right from wrong and they can't kind of put what they're doing into context with others.
And in your opinion, on October 17, 2018, did the defendant have severe schizophrenia?
No.
Did he even have a case of schizophrenia?
No, he did not.
Pass the witness, Your Honor.
Cross.
Yes, Your Honor. Now, before we start, I just want to make clear what it is that you and Dr. Riley actually disagree about. Dr. Riley is the defense expert in this case, right?
Yes, he is.
And you had an opportunity to review his report.
Correct.
Dr. Riley found that Mr. Ray had delusions, hallucinations, and negative symptoms for over a month in his report, right?
He did find that.
And he found that these symptoms caused Mr. Ray to stop being able to take care of himself, right?
Correct.
And these are the reasons that he gave in his report for diagnosing Mr. Ray with schizophrenia.
That is what he said, correct.
But you disagree that Mr. Ray actually had these symptoms, don't you?
I do disagree, especially because there was no evidence of these symptoms until after he was being evaluated in the context of this murder.
Well, Dr. LaGreca, because you disagree with those symptoms, though, you disagree with the schizophrenia diagnosis, right?
That is correct.
But you agree that if Dr. Riley were right about Mr. Ray's symptoms, then Mr. Ray would be schizophrenic, correct?
That is correct. That would meet the DSM criteria.
Now, to be clear, Dr. LaGreca, Mr. Ray has never been your patient.
No, he has never been my patient.
Mr. Ray was Dr. Riley's patient.
Yes, he was.
Dr. Riley evaluated Mr. Ray in person twice.
That is correct. However, I reviewed Dr. Riley's evaluations and he was very explicitly clear even on mannerisms and tone and cooperativeness. So I have all the information that he should have if he documented correctly.
Now, Dr. LaGreca, on direct examination, I just want to make clear, you noted that the defendant claimed, you pointed out when the defendant claimed symptoms after his arrest and when he didn't, right?
Yes, I did.
But part of your job as a psychiatrist is to observe the patient for yourself to see whether they're showing signs of the symptoms.
Yes, that can be true when we have the opportunity to do that. However, I had no opportunity to do that.
That's right. And in your report, Dr. LaGreca, you point out that evaluating Mr. Ray is the best way to diagnose him.
That is true. However, I can use another doctor's evaluation if it was done correctly and documented correctly.
Well, Dr. LaGreca, I'd like to move on now. We'll come back to why you disagree with Dr. Riley, but I want to first look at what you two share in common. You're both forensic psychiatrists.
Yes, we are.
You're both here to give an opinion on whether Mr. Ray has schizophrenia.
Yes, we are.
And you both rely on the DSM-5 to diagnose schizophrenia.
Yes, just like every other doctor in the whole world.
And I just want to take a second to be clear on what the DSM-5 actually does. It provides 4 factors to consider if somebody's malingering.
Correct.
But the DSM-5 actually provides specific criteria that must be met in order to diagnose schizophrenia.
Okay.
Is that a yes to?
Yes.
And it tells you how to apply those criteria.
Yes, it does.
It lists 5 symptoms of schizophrenia.
On the for schizophrenia, correct, it does.
And one of those symptoms is delusions.
Correct, that is one of them.
And delusions are beliefs not based in reality, right?
That is correct, yes.
Delusions can be kind of confusing. So I just want to start by going through a couple of examples.
Okay.
If a person believes that they're being watched, but there's no evidence that they're actually being watched, that could be a delusion.
That could be.
And if a person believes that the CIA is out to get them, but there's no evidence that the CIA is actually out to get them, that could also be a delusion.
Yes, that could be.
Let's talk now about what it means for a person to experience delusions. If a person believes that the CIA is after them, they might lock themselves in their house and shut the doors.
That's true, that could happen.
They might smash up their cell phone.
Correct.
They might take their kid out of school.
Correct.
And they could think that taking their kid out of school was the right thing to do.
Correct.
Because of their delusions.
Yes.
You know the legal definition of insanity, right, Dr. LaGreca?
Yes.
So one way to meet that definition is when a severe mental disease or defect makes a person unable to understand that something they did was wrong.
That is the definition. However, I don't think it applies in this case. I don't think that would.
Right. So Dr. LaGreca, we've got delusions down, I think. So I want to take a hard look now at some of the risk factors that make Mr. Ray's schizophrenia more likely. Childhood trauma increases the risk of schizophrenia.
So yes, all of these risk factors that we talked about increase the risk, but it's not a correlation. There's not a direct causation if you have trauma versus if you have childhood trauma versus if you have schizophrenia, because many people have childhood trauma that don't have schizophrenia, but you are correct. That is
Dr. LaGreca, just to answer clearly here, my question was that childhood trauma increases the risk of schizophrenia, right?
Yes, that is true.
And anxiety as a young man also increases the risk of schizophrenia.
That is true.
Family history of severe mental illness increases the risk of schizophrenia.
That can be true.
And in your report, you found that Mr. Ray suffered from childhood trauma.
Yes, I did.
In your report, you found that Mr. Ray's anxiety started as a young man.
Yes, his anxiety did start as a young man. However, for many years, he was not treated for it. For many years, he did not mention it to even his PCP. So I can't speak for him, but there is no specific evidence that it was very severe for his whole entire life.
But to be clear, Dr. LaGreca, my question was that you found that Mr. Ray had anxiety starting as a young man.
Correct.
And in your report, you also found that Mr. Ray's mother suffered from severe mental illness.
So Mr. Ray's mother was never diagnosed. So us as doctors definitely do not like to say that for someone who's not been diagnosed by the DSM-5.
Certainly, Dr. LaGreca, that's understandable. But in your report, you found that his mother was so mentally ill that she was institutionalized for her mental illness.
Correct. She was institutionalized. However, we have no specific diagnosis for her.
Now, your conclusion in this case is that Mr. Ray was probably faking his symptoms, right?
Yes, that is what my conclusion is.
And you reviewed a transcript of an interview between Detective Booth and Mr. Ray in this case?
Yes.
But there was no video of that interview for you to look at, right?
No, there was not.
Dr. LaGreca, you agree that today is the first time that you've ever seen Mr. Ray?
Yes, it is. However, I've read everything that everyone has on the joint exhibit list, so I do feel that it was appropriate for me to make a medical diagnosis without having seen him personally in person.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor. Dr. LaGreca, can you please remind the jury why you weren't able to do an in-person evaluation of the defendant?
Yes, I was not allowed to do an in-person evaluation.
Who didn't allow this?
Timothy Ray's legal team did not allow me to do that.
Thank you, Dr. LaGreca.
Objection, Your Honor. We would ask that that last statement by the witness be stricken from the record. It is improper. The legal team doesn't have an opportunity to respond, and Mr. Ray is in no position to rebut or confront that evidence, as his legal counsel cannot be witness in his own case.
I understand your objection. I'm going to overrule it. You went into that line of questioning, and so this witness will be able to explain the reasons as to why she did not conduct that in-person interview. So overruled.
Your Honor, I have no further questions for this witness. May she step down?
Yes, Dr. LaGreca, you will be dismissed. State, do you have any other evidence you wish to give at this time?
No, Your Honor.
All right, so does the state rest?
Yes, Your Honor, the state rests.
Defense, do you have any motions you would like to make?
Yes, Your Honor, we would move for a judgment of acquittal at this time. We don't think that the state has met their burden, even in the light most favorable to them, beyond a reasonable doubt, because we don't think they've proven the requisite mental state that Timothy Ray acted intentionally when he committed murder. Again, they've charged Mr. Ray with first-degree murder, and a part of that means they have to prove that he acted with malice aforethought. From the opening statement today, the prosecution has framed their argument as if Mr. Ray had lost his temper. Again, we think that this would at most be second-degree murder or another charge, and certainly no reasonable jury could find that they've met their burden in this case.
State, what's your response?
Yes, Your Honor. We believe we have proved beyond a reasonable doubt that the defendant murdered Nathan Ray. But in looking to that second element, malice aforethought, in the jury instructions, it says malice aforethought can mean one of two things. It can either be that the defendant killed his son intentionally, willfully, or that he acted with callous and wanton disregard for human life. And we proved that beyond a reasonable doubt when he sat on his bed and decided to, when Detective Booth testified that the defendant told him, he went and sat on his bed, made the decision to go grab that belt and walk back into the room and strangle his son.
All right, defense, I'm going to respectfully deny your motion. Would you all like a 4-minute break before we proceed to the defense's case in chief?
Yes,
That
Your
would be wonderful, Your Honor. Thank you.
All right, so let's return back at 2:50. While we're on break, please turn off your video and mute your microphone.
Thank you, Your Honor.
Are the parties ready to proceed to defense case in chief?
Yes, Your Honor, the state is ready.
The defense is ready as well, Your Honor.
All right, defense, call your first witness.
I believe my co-counsel is still walking back to her room. Just give her a few seconds.
Understood. Miss Oblisk, you are muted.
Apologies, Your Honor.
Understood. We're all learning. Please call your first witness.
Thank you. Your Honor, we are ready to call Officer Wentz to the stand. Good afternoon, Officer Wentz. Could you introduce yourself to the jury?
Hello, my name is Officer Peyton Wentz, W-E-N-T-Z.
Were you the officer who arrested Mr. Ray?
Yes,
Where were you when you arrested him?
I was working a sobriety checkpoint.
Was this the night after Nathan's death?
Yes, it was.
When you arrested Mr. Ray, did you know that Nathan was missing?
No, I had no idea.
All right, Officer Wentz, since you didn't know that Nathan was missing when you arrested Mr. Ray, I'd like to talk about the events leading up to his arrest that night. When you first approached Mr. Ray, what did he look like?
He was completely disheveled. His eyes were glazed over. It looked like he hadn't showered in multiple days. He had stains all over his clothes. His appearance was overall just very alarming.
So you described him as disheveled and dirty, but how was he behaving when you first encountered him?
He was completely paranoid and frantic.
So you mentioned that this happened at a sobriety checkpoint. Did you think there was any chance he could be drunk?
No, he was not acting intoxicated, but he was acting really strange.
Now, you also described Mr. Ray as frantic. What was he doing that made him seem frantic to you?
Well, he was moving around a lot, very fidgety. In addition, he said some alarming things to me.
What were these alarming things?
He told me that he thought I was with the CIA and that he could hear a lot sirens and that the CIA was coming to get him.
Did you hear sirens?
No, there were no sirens.
So how did you respond to Mr. Ray's accusation that you were part of the CIA?
I informed him multiple times by showing him my badge that I was not with the CIA and he was in fact conversating with a police officer.
So after repeatedly telling him that you weren't with the CIA, did he seem to understand what was going on?
No.
Did you have him get out of the car?
I did. I asked him to get out of the car.
Well, let's look at how he was behaving once he got out of the car. What was he like then?
He was like a completely different person. It was a complete shift in his behavior. The best way I could describe it is he became like a zombie. He was talking in a monotone. He was moving very slowly. It was very weird.
Based on what you saw going on around you, was there anything happening that could explain his behavior?
No, the only thing that was going on was his weird behavior.
So I want to talk about what else you might have seen him do in front of you that night, officer. If anything, what other behavior stood out to you?
Well, at one point, he started doing jumping jacks.
Did jumping jacks seem appropriate to you under the circumstances?
No, of course not. He was in the middle of an interaction with a police officer.
How long did he keep doing the jumping jacks?
Well, I told him verbally to stop doing jumping jacks, but he continued to do them. And I had to resort to pulling my gun on him to get him to stop.
What happened when you pulled your gun out?
So he did stop doing jumping jacks, but he continued to bob his head around and move physically, and he put his hands over his ears like this, like he was a little kid trying not to hear something.
No further questions, Your Honor.
Cross-examination.
Yes, Your Honor. Officer Wentz, I'd just like to clarify the timeline of the events for the jury. You said when you approached the defendant, when you arrested him, that he was disheveled.
Yes,
And you asked for his ID, right?
I did.
And after you took his ID, you ran back to your partner to give him the ID to run his information.
Yeah, I ended up giving his information to my partner.
And then it was only once you returned back to the defendant's vehicle that he started asking you strange questions.
Yeah, he started asking me very strange questions.
He asked you if you were in the CIA.
He accused me of being with the CIA, yeah.
Right, he accused you of being with the CIA. And you said when you asked him to get out of the vehicle, he started doing jumping jacks.
After he got out of the vehicle, he started doing jumping jacks, yes.
And you described his behavior as strange at this point.
Yeah, his behavior was really strange.
But the CIA question and the jumping jacks, those were after you had already taken his ID.
Yes, after I had his ID.
And as a traffic police officer, you know that when you pull someone over, you're going to ask for their ID.
Yes, of course.
And you know that probably people, when they're pulled over, they can assume that the police that's pulling them over will ask them for their ID.
Yeah, most likely.
It's pretty common practice.
Yes, it's common to ask someone for their ID when they're pulled over.
So because it's common, someone giving their ID to a police officer would probably know that that police officer is going to go run their ID.
To identify who they are, yeah.
Right, to identify who they are, and that the police would know who they are within a few minutes.
Presumably, yeah.
Officer Wentz, I'd like to talk about your why you're here today. I just want to be clear for the jury, you are not a psychologist, right?
No.
You are not a psychiatrist, right?
No, I'm not.
And you're not qualified to make a diagnosis.
No, I can't diagnose someone.
You're just here to tell the jury what you saw in the defendant that night, right?
Right, what I observed.
What you observed, and the CIA and the jumping jacks. Again, that all happened after you took his ID, right?
Yes, he started asking those questions after, yes.
No further questions, Your Honor.
Any redirect?
Yes, Your Honor. Officer Wentz, if you learned that Nathan was missing after you handcuffed Mr. Ray, why did you arrest him when you did?
Well, I put handcuffs on him because he was acting completely erratic and was moving around physically in a way that made me concerned for his safety and my own.
No further questions, Your Honor. May this witness be excused?
Yes, thank you, Officer Wentz. You may leave the Zoom meeting. Defense, when you're ready, call your next witness.
Yes, Your Honor. The defense calls Shane Riley to the stand. May I inquire?
Well, first, Dr. Riley, you will be constructively sworn in. And yes, you may inquire, Mr. Richards. Go ahead.
Thank you, Your Honor. Good afternoon, Dr. Riley. Could you please introduce yourself to the court and spell your last name for the record?
My name is Dr. Shane Riley. Last name is spelled Reilly.
Dr. Riley, what sort of specialty are you in?
I'm a forensic psychiatrist.
What is forensic psychiatry?
Forensic psychiatry is a subsect of psychiatry in which we deal directly with the legal system.
And how are you involved in this case?
Yes, I was hired to evaluate whether Mr. Ray, Nathan Ray's dad, suffered from severe mental disorder when he killed his son.
let's talk about your qualifications to make such an evaluation. As a forensic psychiatrist, what education do you have?
I received my medical degree from the Uniformed Service University.
Do you have any work experience in the field?
Yes, I do. Initially in my career, I worked for the US Army, in which I oversaw approximately 20,000 soldiers as a forensic psychiatrist. After that, I worked in the Walter Reed Clinic, in which I diagnosed and treated numerous mental health disorders, including schizophrenia.
Are you still at Walter Reed today?
No, I'm not. I own my own private practice.
Have you ever been published in the field of forensic psychiatry?
Yes, I have. I've published approximately 15 peer-reviewed journals, of which 2 were directly dealing with schizophrenia.
I want to talk more about your work in this case. Without going into any specifics, were you able to diagnose Mr. Ray with a mental disorder?
Yes, I was.
What did you base that diagnosis off of?
I based my diagnosis off of multiple clinical interviews that I've personally conducted, off the exhibits in this case, off of other interviews conducted by other personnel.
Was there anything beyond your interviews that you conducted in this case?
Yes, I also reviewed Dr. LaGreca's report as well.
Between Dr. LaGreca's report, your interviews, and treatment, did you have a sufficient amount of facts and data to form your opinion in this case?
Yes, I did.
Did you use reliable principles and methods in forensic psychiatry to make your diagnosis?
Yes, I did.
And did you reliably apply those same principles and methods to the facts of this case?
Yes, I did.
Your Honor, at this time, the defense moves to admit Dr. Riley as an expert in forensic psychiatry.
Any objection?
Yes, Your Honor. The state objects to the generality of the designation. We believe that this expert may be qualified to give an opinion, but only in the area of military forensic psychiatry. May I take this witness on voir dire?
Yes, you may.
Dr. Riley, the entirety of your medical education was all in connection with the military, correct?
Yes, that is correct.
And you're aware that there are specific disorders that tend to be more common in military personnel?
Yes, that's definitely true.
You would agree that the majority of your patients are active duty military or veterans?
Early in my career, after which I also own my own private practice currently, where I deal with numerous citizens as well.
Correct, but in your private practice, the majority of your patients that you see are active duty military or veterans, correct?
Yes.
You would agree that you're not treating the same sample population as of patient as a civilian doctor?
While the sample population may differ, mental health diseases can range in them too. While few mental disorders are slightly more prevalent than citizens, we do see all of them.
Dr. Wright, that was a yes, right? Your sample population of patients is different.
Yes.
Your Honor, this concludes our offer of proof. At this time, we re-urge our objection to the generality of the designation.
Defense, do you have any response to their objection?
Yes, Your Honor. Dr. Riley has testified that he has experience beyond just working with military personnel. In fact, he testified that he worked as a forensic psychiatrist for Walter Reed Medical Hospital, where he treated thousands of patients with a variety of mental disorders, not just schizophrenia. And furthermore, Dr. Riley also testified that he now runs his own private practice. And while the majority of his clients might be military personnel, that doesn't preclude him, or it doesn't mean that he also doesn't treat other patients and diagnose them with mental illness. Therefore, we believe the general designation as a forensic psychiatrist would be appropriate in this case.
Yes, I'm inclined to agree. And so, counsel, I'm going to overrule your objection. The witness did testify that he has a private practice in which he treats numerous citizens, despite the fact that the majority of those citizens may have been veterans. So for that reason, your objection's overruled, and Dr. Riley will be tendered as an expert in the area of forensic psychiatry. You may proceed.
Dr. Riley, what did you diagnose Timothy Ray with?
I diagnosed Mr. Timothy Ray with severe schizophrenia.
What is schizophrenia?
Schizophrenia is a mental disorder that's defined in the DSM-5. It can be quite severe and affects approximately 1% of the population.
How often do symptoms of schizophrenia present themselves?
It can be very variable, and it depends on the severity of the disease itself. Sometimes it can be intermittent, sometimes it can be quite frequent and quite deleterious to one's personal health.
And in your profession, are you familiar with the legal definition of insanity?
Yes, I am.
Your Honor, at this time, may I project onto the screen the legal definition of insanity, as well as the DSM-5 criteria for diagnosing someone with schizophrenia. Opposing counsel had a chance to review this PowerPoint prior to trial today and had no objections.
There's no objection from the state, then you will be permitted to do so.
In order to prove an insanity defense, the defendant must show by clear and convincing evidence, first, that they suffered from a severe mental disease or defect at the time constituting the offense were committed, and two, as a result, the defendant was unable to appreciate the nature and quality of his acts or was unable to appreciate that what he was doing was wrong. Dr. Riley, I want to focus on that first prong of insanity. In your profession, is schizophrenia a severe mental disease or defect?
It definitely can be. It presents itself on a spectrum, so it's variable in patients, but it definitely can be extremely severe.
And moving on to that second prong, can schizophrenia be severe enough where someone wouldn't be able to appreciate what they were doing was wrong?
It certainly can.
Now, earlier you mentioned the DSM-5 as the standard bearer for diagnosing someone with schizophrenia. And we've heard a lot about the 5 criteria in the DSM-5 throughout trial today. Dr. LaGreca, the state's expert, says that Mr. Ray doesn't show any of these symptoms. Do you agree?
No, I don't agree with Dr. LaGreca.
What symptoms did you find that Timothy Ray showed?
Timothy Ray, of the symptoms classified for schizophrenia, he showed delusions, hallucinations, and negative symptoms.
Delusions, hallucinations, and negative symptoms. I want to break each one of those down individually, starting with delusions. What exactly is a delusion?
Delusions are generally beliefs that are not based off of any real reality.
What delusions did you find in Mr. Ray?
Mr. Ray showed several evidences in which could be classified under delusions. In 2014 or in 2015, he feared his wife and his son were trying to cut him up. In 2016, he noted that in Dr. Giuseppe's interview, he noted that she was colluding with his wife. In 2018, when Officer Wentz and Detective Booth met Mr. Ray, he accused them of being part of the CIA despite evidence to the contrary. And finally, in the most recent interview with me, he accused me of holding video cameras in the microwave, despite, again, evidence to the contrary.
And Dr. Riley, you mentioned Dr. Di Giuseppe in your response. Exactly who is Dr. Di Giuseppe?
Dr. Di Giuseppe is Mr. Ray's primary care physician.
Now let's move on to hallucinations. Please explain what a hallucination is.
Hallucinations are sensory stimuli that don't have any real no reality to them. For example, they can be auditory, visual, tactile, and a few others.
Did you ever find that Mr. Ray hallucinated?
Yes, I believe that Mr. Ray suffered from 2 types of hallucinations, one visual and the other auditory. In 2016 or 17, I believe that Mr. Ray talked about seeing triangles on the wall, which is an example of a visual hallucination. Another example of an auditory hallucination that he experienced was he mentioned since the age of 10, he heard voices talking to him. He mentioned that in approximately 2017, these auditory hallucinations reappeared and worsened during the times leading up to October 2018.
Now, finishing up with negative symptoms, what are those?
Negative symptoms refer to the inability to do something, and this can cause profoundly negative impacts on one's life. Negatives, inability to do something can be inability to maintain basic hygiene, inability to control emotions, and they can all produce negative outcomes.
Was there evidence to suggest that Mr. Ray couldn't maintain basic hygiene or control his emotions, showing a negative symptom?
Yes, actually, in two separate examples, he was noted to not have showered in weeks. Dr. DiGiuseppe mentioned this, and Officer and Detective Booth mentioned this when he met him outside the clinic. In addition, Officer Wentz and Detective Booth, when they saw Mr. Ray at the toll booth, they also mentioned that he was malodorous and disheveled.
Thank you, Dr. Riley. Is there any cause of schizophrenia that's accepted in your field?
There's no particular cause for schizophrenia, but there are things that are highly associated with it. For example, genetics, childhood trauma, and in addition to that, comorbid psychiatric disorders are all highly associated with schizophrenia.
Were any of the items that you mentioned were highly associated with schizophrenia found in Mr. Ray's case?
Of the ones I mentioned, actually all three were. In regards to his mother, while she wasn't dealt a specific diagnosis, she did experience symptoms similar to schizophrenia and was later institutionalized. She was also mentioned to be neglectful and abusive to Mr. Ray. And finally, in 2010, he did in fact suffer from comorbid psychiatric disorders. In 2010, he was diagnosed with anxiety and also showed evidence of some depressive symptoms. And there was also, he also mentioned an example of during his time in the Army, where he had some passive suicidal ideation.
You mentioned that Mr. Ray's mother was neglectful or abusive. Does that constitute childhood trauma in your field?
It certainly can, yes.
I want to move forward to the day in question, October 17th, 2018. In your professional opinion, was there any evidence to suggest that Mr. Ray was suffering from severe schizophrenia when he killed his son?
Yes, I believe during the episode of October 17, 2018, he was evidenced to have auditory hallucinations when he mentioned that this was the only way to remove evil from his son. He also showed examples of delusion, one when he accused Officer Wentz and Detective Booth of being part of the CIA. Additionally, he also noted that Nathan spelled the juice on his laptop purposefully as a way to sabotage him by his wife.
No further questions.
Cross-examination.
Yes, Your Honor. Dr. Riley, you're familiar with malingering, right?
Yes, I am.
You know malingering means faking symptoms,
Yes, the simulation of symptoms.
and patients do sometimes fake symptoms, right?
Yes, certainly.
To avoid work,
Yes,
to get out of military service,
sure,
and sometimes to avoid criminal charges, right?
certainly.
You would agree with me that when a psychiatrist evaluates someone's mental health in a context like this one, you have to consider malingering, right?
That is very true. You have to consider malingering.
You should always be on the lookout for the signs,
Yes.
and you should never dismiss them when they're present.
Malingering is generally a diagnosis of exclusion, but yes.
And you would agree with me that anytime the severity or frequency of someone's symptoms increases after they've been charged with a crime, that's signifies the potential for malingering, right?
I don't think that applies to this case, but yes, that could, yes.
For example, a subject in police custody who suddenly begins to act out. Correct. That's a situation like I described.
Yes, it could.
And you would agree with me that generally, the more serious a crime, the greater the likelihood of malingering.
Yes.
The more severe the punishment potential, the greater the likelihood of malingering.
Yes.
You agree with me, murder is a criminal charge, right?
Yes.
It's the most serious crime a person can commit.
I believe so, yes.
The defendant potentially faces years in prison, right?
Yes.
Maybe even life.
Yes.
We can agree that going to prison changes everything for someone, right?
Yes, I'm familiar, but yes, it could. I
It'd be
imagine.
difficult to get a job as a convicted murderer.
Yes.
So if there's anything a person could do to avoid that, it's at least tempting, right?
Yes.
So let's talk about what we know about this defendant before he was charged with murder.
Yes.
You know someone with severe, untreated schizophrenia, that would impact how they go about their daily lives, right?
Yes.
It would make it difficult, if not impossible, to hold a job long term.
It depends on the severity of the schizophrenia. So
Right.
it depends on the severity, yes.
For severe, untreated schizophrenia, it would make it near impossible to hold down a job long term.
Yes.
So let's talk about this defendant and his supposed severe, untreated schizophrenia. You'd agree with me, before your evaluation, after he was charged with murder, the defendant was never previously diagnosed with schizophrenia, right?
He was never diagnosed with schizophrenia, yes.
He served in the military.
Yes.
He has no criminal record.
Yes.
He got married.
Yes.
He became a father.
Yes.
He held a job at Computerland
Yes.
for years, right?
Yes.
And then it was only after he strangled his son that he called you, right?
I met him earlier, but yes.
Yes. And at that point, after he was charged with murder, you diagnosed him with schizophrenia.
Yes.
So let's talk about what we know about the defendant after he was charged with murder. After being charged with murder, the defendant told you about all these symptoms that you testified to previously, right?
Yes, but I didn't just rely on what he told me. I also relied on evidence gathered by other interviews and other people prior to this.
Correct. But the first time the defendant told anyone, any doctor, about these symptoms, you agree with me, is after he was charged with murder, right?
The first time he expressed these symptoms was afterwards, yes, in a clinical setting.
And after being charged with murder, the defendant claims that he began hearing voices all the way back as a child, right?
Yes.
And the first time any doctor is hearing about this is after he was charged with murder.
Yes.
You evaluated the defendant in 2010, correct?
Yes.
And at the time you evaluated him, the defendant, in fact, expressly denied ever hearing any voices. Isn't that right?
There was anecdotal evidence, but from Officer Cruz, I believe, that did mention that he may have been hearing things, but at that point, I denied any hallucinations or delusions at that time.
The defendant denied it to you, correct?
Yes.
He just told you that he had been feeling anxious, right?
Yes.
Depressed.
Yes.
He'd been having trouble sleeping.
Yes.
He missed home.
Yes.
You'd agree with me that these aren't out of the ordinary for military personnel, right?
I guess not, no.
And you diagnosed the defendant with generalized anxiety, correct?
I did diagnose him with generalized anxiety disorder.
But now, despite what the defendant told you then, now you believe that he was hearing voices as far back as 2010, right?
Yes.
If you're right now, that means he lied to you in 2010, didn't he?
He denied them then, yes.
And in fact, the defendant lied so well, he convinced you that.
Objection, argumentative.
This is cross overruled.
In fact, he lied so well that you believed he wasn't hearing voices, right?
I did not believe he was experiencing hallucinations at that time.
So let's talk about when the defendant would be more likely to lie. You would agree that a diagnosis made before someone is charged with a crime significantly decreases the chances of malingering, right?
Yes.
And those chances of malingering, that would be decreased even further if there was outside objective evidence like hospitalizations or treatment from other doctors that corroborated that diagnosis, right?
Yes.
That way you wouldn't have to guess or speculate.
Yes.
Because there would be objective evidence as well.
There was objective evidence otherwise through other other interviews conducted here.
Right, that wasn't my question. There would be objective evidence as well in a situation like I described, not specifically in this case.
Yes.
Dr. Riley, just because someone loses their temper, that doesn't mean they have schizophrenia, right?
No, certainly not.
Pass the witness.
Any redirect?
Yes, but before I begin, Your Honor, I'd like to strike something from the record that opposing counsel had talked about it. They mentioned potential punishments of Mr. Ray being convicted in this trial today. Normally, in a setting that's not in a virtual mock trial world, we would ask for a mistrial, but for the purposes of today, we just ask that it constructively be stricken from the record.
That is an excellent objection to make. I would wholeheartedly agree. However, your objection is untimely. You allowed counsel to ask, I think, 3 or 4 questions about potential sentencing and the effects of that sentencing. So although I'm inclined to agree because your objection is untimely, I'm going to overrule it. You may proceed with your redirect.
Thank you, Your Honor. Dr. Riley, Dr. LaGreca and the state believe that Mr. Ray is malingering. Do you agree?
I don't believe Mr. Ray is malingering as he meets the DSM-5 criteria for schizophrenia.
Why specifically don't you agree that he's malingering?
I believe malingering is a diagnosis of exclusion. So in this case, I believe he does meet the criteria of schizophrenia. Schizophrenia requires 2 or more of the following symptoms, of which I believe that he suffers from hallucinations, delusions, and negative symptoms, all of which I believe were evidenced even prior to the criminal cases, especially negative symptoms with his lack of basic hygiene, also his lack of emotional control. Additionally, in terms of delusions, I believe he did noted to have been experiencing delusions prior to this case being conducted as well.
Do symptoms of schizophrenia appear all at once?
Objection, leading.
Overruled.
Dr. Riley, I'll go ahead and repeat the question. Do symptoms of schizophrenia appear all at once?
Schizophrenia can present itself in a very various manners. In most people, it presents itself gradually and worsens as it goes on, especially if it's untreated.
Opposing counsel talked a little bit about the timeline of Mr. Ray's symptoms. Why might someone conceal symptoms of mental illness?
In many cases, at least personally, what I've experienced is that people don't want to believe that they're experiencing mental illnesses. And so they a lot of times disregard it until it becomes more pervasive or more intrusive into one's life.
And you also mentioned that it's helpful to have a diagnosis from another treating physician for mental illness. Is that necessary in your field?
It certainly helps.
But is it something you have to have?
Diagnosis from a...
I'm sorry, what was the objection, counsel?
Deleting, Your Honor.
And I'm sorry, I missed the question just because it got a little tricky. Mr. Richards, can you repeat your question, please?
Yes, I asked the witness, Your Honor, if having a diagnosis from a treating physician is required.
Overruled.
Dr. Riley, is a diagnosis from another treating physician required before diagnosing someone with schizophrenia?
No, it is not required.
No further questions.
All right, Dr. Riley, you are dismissed and you can leave the Zoom meeting. Defense, do you have any other evidence you wish to present today?
No, Your Honor, the defense is ready to proceed to closing arguments.
All right, before we proceed to closing arguments, I want to take another 4-minute break. So we'll meet at what's my time, 3:30, but whatever time that applies to you at 30. When we come back at that time, can we please have the time calculated so that both attorneys know how much time they have for summation? All right, so let's actually make it 3:31 because now it says 3:27 for me, and I want to give you time to add that up and then use the restroom and take a drink if you need to, okay? Please turn off your camera and mute your microphone at that time.
Thank you, Your Honor.
All right, now that we're back, timekeepers, you don't have to turn on your camera, but can you unmute yourself and just give me the time for each side?
Yes, Your Honor. The official time that we agreed on was that the prosecution has used 47 minutes and 2 seconds and has 7 minutes and 58 seconds remaining. And the defense has used 42 minutes and 52 seconds and has 12 minutes and 8 seconds remaining. We also did post that in the chat here on Zoom so folks can see.
Yes, I see it. So my apologies, I didn't look to the right. Wonderful. So that sounds like plenty of time for both sides. And so we will now hear closing arguments from each party. Hopefully the parties are ready. Jurors, if you have not already switched back to speaker view, I'm told to encourage you to do so. Prosecution, you may begin closing argument when you're ready.
Your Honor, at this time, may I request 7 minutes for argument and the 58 seconds for rebuttal? May I reserve that, please?
Yes, would you like any like notifications based on how much time you have left?
No, that's okay. Thank you, though, Your Honor.
Okay, no problem.
May it please the court, members of the jury, you've heard today that the defendant claims he lost his grip on reality when really he just lost his temper. Nathan Ray was in the 1st grade. He had his whole life ahead of him to live. But now, because of the defendant's choice to grab a belt and strangle his own son, Nathan will never kick a soccer ball again. Nathan will never graduate from high school and apply to colleges. And every day, Nathan's mother, Jessica, she walks by an empty room in her house. And every day, when she's driving, she instinctively looks in her rearview mirror, but sees no one. A parent should never outlive their child, especially at the hands of that child's own parent. You've heard today that on the morning of October 17th, 2018, 6-year-old Nathan Ray, he ate his last meal, a bowl of Frosted Flakes. And then when he reached for that glass of apple juice, it spilled on his father's laptop, the defendant's laptop. The defendant got angry. He wanted to punish his son for destroying his computer. So he chased Nathan into his room, where he forced him to do physical punishment. But Nathan wouldn't stop crying. This just made the defendant angrier. So he went to his room, he grabbed his belt, he came back to Nathan, and he beat Nathan, he slapped Nathan, he hit Nathan with that belt. But Nathan wouldn't stop crying, so he put that belt around Nathan's neck, he tightened it, and he pulled. He pulled on that belt until Nathan was dead. You heard today that as soon as Nathan wasn't heard from at school, his mom filed that missing persons report. Detective Booth told you about the night they arrested the defendant, and he told you about his confession. You saw what was in his car. You heard what was in his car, the bottles of bleach, black trash bags, and a dirty shovel. You heard Detective Booth tell you about their search for Nathan's body in Brandywine State Park. You heard that after they found Nathan's body, shoved inside a black trash bag, left to rot, he had to call Jessica, Nathan's mother, and make that phone call. You saw the room where Nathan was killed, the belt on the floor next to his toys. And after killing Nathan, the defendant, he realized what he did was wrong. You heard Detective Booth tell you about what they found on his phone, the Google searches. The defendant, he tried to cover up what he did. He Googled how to hide a body and will bleach destroy a body. He needed to know this information so he could hide his evidence. But not only that, he Googled countries that don't extradite for murder charges. The defendant was going to literally flee the country to escape responsibility for killing his son. This proves that he knew that what he did was wrong. He knew he was going to get caught. He knew. And we told you during opening statements that we have the burden of proof in this case as a state. We had to prove to you beyond a reasonable doubt that, one, the defendant killed Nathan Ray. We proved that to you. We also had to prove that he killed Nathan Ray with malice aforethought. And malice aforethought can mean one of two things. It can mean either the defendant killed Nathan willfully and intentionally, or that the defendant killed Nathan by wrapping the belt around his neck, and that that act was with callous and wanton disregard for Nathan's life. Now, certainly, there's no doubt that he knew putting the belt around the neck would kill him. We've proved to you beyond a reasonable doubt. And this reasonable doubt requires moral certainty that leaves you with no hesitation to act, no hesitation to find him guilty. Ladies and gentlemen, the defendant didn't hesitate when he chased Nathan into his room. The defendant didn't hesitate when he put the belt around his neck. The defendant didn't hesitate when he killed Nathan. Because you found the defendant, because the defendant was found guilty, and we prove this beyond a reasonable doubt, after finding that he's guilty, you then have to decide if the defense proved to you that he was insane at the time he killed Nathan. The defense had to prove this to you by clear and convincing evidence. This means that their story is highly and substantially more likely to be true than not. But you heard the evidence. You heard from Dr. LaGreca, forensic psychiatrist with years of experience. She's done extensive research in her field. She showed you how psychiatrists diagnose patients. She showed you what symptoms to look for. And we looked at these symptoms. There was no corroborating evidence from before the defendant was charged with this murder, that he had delusions, hallucinations. But after his arrest, suddenly the defendant is having these delusions and has been having them for his whole life almost. And suddenly after his arrest, he's been having hallucinations and hearing voices his whole life. I ask you, members of the jury, is the defendant's story substantially more likely? We know he was trying to escape his responsibility as soon as he killed Nathan. But now after being charged with murder, again, he's being faced with responsibility, and suddenly he has a mental illness that was so severe he didn't understand right from wrong. Timothy Ray claims to have lost his grip on reality, when really he just lost his temper. Thank you.
Thank you, State. Defense, proceed when you're ready.
No one here questions that killing Nathan Ray was wrong. It was wrong. But the question is not whether it was wrong. The question is whether Mr. Ray understood it was wrong when he did it. Today, we're asking that you find Mr. Ray not guilty by reason of insanity, because the law recognizes that insane people are not as responsible for what they do as sane people are. Take a speeder who speeds right through a red light at an intersection and compare them to a person who has a seizure and suddenly loses control of the car. Both cause a car crash. Both hurt other people. But only the speeder is responsible for hurting those people. Mr. Ray is like that driver with the seizure. When he has a psychotic episode, it happens fast. Remember what we know about insanity. Insanity is not a steady state. A person who's insane isn't always insane at every single moment of their life. Psychotic episodes come and go, and they can be followed by moments of clarity. Mr. Ray's psychotic episode caused him to lose touch with reality. Delusions are beliefs not rooted in reality. And Mr. Ray was not rooted in reality when he did what he did. Now, when you find Mr. Ray not guilty by reason of insanity, it doesn't mean that he didn't cause a death. It means that he didn't understand that what he was doing was wrong. And the law treats him differently because of it. Now, I want to talk about what it really means to find Mr. Ray not guilty by reason of insanity. It is the prosecution's burden here today to prove beyond a reasonable doubt that first-degree murder occurred. But if you find that they did this, then it becomes our job to show that Mr. Ray was insane at the time it happened. So what is legal insanity? It means that a person has a severe mental disease or defect that makes them unable to understand that something they're doing is wrong. What does that mean for Mr. Ray? It means that if Mr. Ray's delusions and schizophrenia made him unable to understand that killing Nathan was wrong, then he's legally insane. And he's not guilty by reason of insanity. So let's look now at the evidence that we have of Mr. Ray's legal insanity. And let's start with his diagnosis of severe schizophrenia. You heard from Dr. Riley here today. Dr. Riley is the only psychiatrist who has actually treated Mr. Ray, who's actually seen Mr. Ray. And Dr. Riley found that Mr. Ray suffered from hallucinations and delusions and negative symptoms lasting over a month. In fact, he found that Mr. Ray had these symptoms for years. Now, we're about to get into these symptoms, and you'll notice a pattern. See, each time Mr. Ray's symptoms were at their absolute strongest, his hygiene went downhill. Because Mr. Ray, when struggling with his schizophrenia symptoms, couldn't take care of himself. He was overwhelmed with his illness, and he stopped taking care of himself. So let's come back and talk now about what we know from Dr. Riley's interviews of Mr. Ray. We know that from Dr. Riley's first interview in 2010, Mr. Ray was diagnosed with anxiety, and contrary to what the prosecution suggests, this actually shows that his schizophrenia is more likely, not less likely. This was 9 years ago. And the fact that he had a comorbid diagnosis for anxiety back then actually shows that he's more likely to develop schizophrenia. And you heard from Dr. Riley that symptoms get worse over time. Mr. Ray's symptoms got worse over time. Let's talk about what we know from Dr. Riley's visit in 2019. Mr. Ray was obviously delusional. He thought there was a video camera watching them from the microwave, despite evidence to the contrary. And he expressed symptoms dating all the way back to his childhood. Now, you might wonder why Mr. Ray waited to share this information with a doctor. But we stigmatize mental illness. You start talking about hallucinations and delusions, and people are going to start treating you differently. People are going to judge you. It might be hard to find or keep employment if your employer knows about it. Is it any wonder that Mr. Ray wouldn't want to talk about his hallucinations and delusions? I want to move now to look at the evidence that we have of Mr. Ray's schizophrenia from around the time of Nathan Ray's death. Let's start with the night of his arrest with Officer Wentz at the sobriety checkpoint. He was disheveled, he was frantic, he was paranoid. He was asking her over and over if she was a CIA agent. He heard sirens that weren't there. And despite the fact that Officer Wentz, she showed him her badge, she explained who she was and that she was a police officer, he didn't seem to understand what was going on. He was muttering to himself and making strange movements. Now let's talk about what else happened that night. Right after his arrest, Mr. Ray went down to the station where Detective Booth interviewed him. And you heard from Detective Booth that Mr. Ray did the same thing with him. Mr. Ray repeatedly asked Detective Booth if he was a CIA agent. Despite the fact that Their kids played soccer together. They know each other. Mr. Ray knows Blake Booth. But he was convinced that he was a CIA agent, and it wasn't getting through to him. Now, Detective Booth told you today that there was nothing out of the ordinary about how Mr. Ray was acting that night. Detective Booth has been a detective for over 20 years. He took a video of that interview, members of the jury, and he didn't save it. He would have you believe that video footage of him interviewing a homicide suspect right after he was arrested wasn't important enough to save. But he had a transcript made for you instead. He thinks that's good enough for you. And I guess you would have to take his word for it. Now, recall that right before this interview, at the sobriety checkpoint, Mr. Ray had just been muttering to himself and doing jumping jacks in the middle of being arrested. And even when Officer Wentz had to pull out her gun, he didn't stop moving. Now, I want to move forward and talk about what we know about Mr. Ray's schizophrenia symptoms from 2 years before Nathan Ray died. You see, you heard about another doctor here today. It wasn't just Dr. LaGreca and Dr. Riley. Mr. Ray had a family physician, Dr. DiGiuseppe, who he saw in the years in between when he was in the military in 2009 and when he was evaluated by Dr. Riley in 2019. And 2 years before Nathan's death, he saw Dr. DiGiuseppe. And during that appointment in her office, Mr. Ray accused her of conspiring against him with his wife. He accused her of listening in on his personal phone calls. His family doctor. Mr. Ray's long history of schizophrenia and delusions explains why he doesn't always understand things the way that a sane person would. Now, I want to talk about one of Mr. Ray's more recent delusions. On October 17th of 2018, Mr. Ray believed that tightening a belt around Nathan Ray's neck would help him understand that his mom had tricked him. Mr. Ray wanted to help Nathan understand. Delusions are beliefs not rooted in reality. And schizophrenia aside, Mr. Ray's delusions explain why he was legally insane. See, delusions are signs of a mental defect. We all agree that defect is not a medical term. It just means that something wasn't working right. And his delusions show that his mind was not working properly. You don't need a diagnosis for that. Mr. Ray was legally insane. When a speeder causes the crash, we blame the speeder. But when the person with the seizure causes the crash, we blame the seizure. We blame the illness. Don't blame Mr. Ray. Blame the illness. Find Mr. Ray not guilty by reason of insanity.
Thank you, counsel. Any rebuttal from the state?
Yes, Your Honor. Could I please get a time check on my rebuttal, please? How much I have left?
Sounds like, oh, there it
1
goes.
minute and 56 seconds.
Thank you.
Thank you. May it please the court. Ladies and gentlemen of the jury, defense counsel just came up here and told you, and I quote, and I quote, insanity doesn't mean he didn't cause a death. But what insanity does mean is that he'll get away with it. Defense counsel claims that one reason why the defendant might not have come forward with his symptoms is because he's afraid of judgment. He's afraid of stigma surrounding mental illness. But I ask you, is he afraid of that judgment now? Is he afraid of that stigma now, after being charged with the murder of his son? Don't let the defendant weaponize a mental illness, a serious mental illness that millions of people struggle with in America. Don't let defense counsel weaponize this mental illness in order for the defendant to go free. We trust you will do justice. Thank you.
Thank you, counsel. All right, so jurors, please complete your ballots. And once you are done completing them, please just indicate in the chat that you are done. And at that point, we can then turn to comments for the advocates. All right, now that it appears that all ballots have been submitted, we are permitted to do some brief comments for the advocates. So if you are an attorney, please put yourself, show yourself on your screen and switch to gallery view if you have not already. Because we do have 3 jurors, 1 presiding judge, I was told to limit the comments. I think what would be most productive for the advocates is to give 1 comment of praise and then 1 comment that is constructive criticism. So I will let the other jurors proceed.
I'm happy to go first. I'm Carol Shelley.
Yes,
are you going to call on somebody, Your Honor?
My apologies. Yes, Juror Shelley, please.
So I do plaintiff's personal injury up here in Pennsylvania. I'm not sure where you guys all are. You're all outstanding. You really were. I would say, Kylie, that your closing, I was a public defender for 4 years, tried a number of murder cases. Your closing was outstanding. I have to say, you know, it's must be awkward to do this on Zoom, but your use of the camera and stepping in and stepping out was incredibly effective. The opening statements to your closing were very powerful, really caught me. And just, you know, this dealing with the bad evidence that he hadn't told anybody about his mental illness for 9 years and the stigma, it just was a really, really well done closing argument. A prosecution, your closing was great as well. The only thing I would say is if you're going to use rebuttal, really use it to bang them with something real strong. And I'm not sure that was an effective use of rebuttal. But otherwise, I thought you guys were all excellent.
Juror McManus? Oh, no, sorry, I'm pronouncing that wrong. McManus.
Hi, great job, everybody. Well done. I wasn't sure how this would go with Zoom, but everybody was very professional and everyone was great. Everyone had great pacing. Everyone had a good use of an understanding of the facts and the law, and everyone did a great job at explaining to the jury what exactly you're asking us to do. You know, not at stake is whether or not he murdered his son. We know that, or not murdered, but you know, he killed his son. The defense, great opening, great closing. Kylie, is that how you pronounce her name? Kylie, great. I agree with juror Shelley. I loved how you did this seizure analogy. I think that was great. And then when you circled back to it, I was like, yes, well done. Good use. Prosecution, good job getting out the bad facts yourselves. It's always better. You guys get the bad facts out, like, oh, your expert hasn't met the defendant. Much better for you guys to get that out. Good job with that. And in the closing, good use of the frosted flakes and the juice. Like, that just shows how innocent this victim was. And then who doesn't like frosted flakes and juice? So well done. Good job.
All right, Juror Bertolini. I apologize if I'm not pronouncing that correctly.
That's okay. It's Bertolino. I'm Elizabeth Bertolino. I'm a catastrophic injury attorney in San Francisco. And so I'll start with comments for everyone. Don't feel the need to redirect. I think there's a redirect on every examination. Redirect should only happen if it's absolutely necessary. And in that case, it should be limited to 1 or 2 questions. It should never, like, there were some cases where I realized the redirect was almost longer than the direct itself. So moving forward, plan on not redirecting and only do it if you truly feel you have to rehabilitate your witness. Prosecution or defense, one thing I really noticed is you tend to do a lot of adjectives and adverbs when you're objecting. You don't have a strong objection. Nothing is outstandingly relevant. Nothing is incredibly prejudicial. It's an objection, it's relevant, and it's prejudicial. So take away those kind of flowery adjectives and adverbs, because it actually takes away credibility for you, because it's the judge's decision to decide whether they're relevant or they're prejudicial. And it's you interjecting your opinions by saying that. Prosecution, I'd like it if you were a little closer to the screen. I know we tried to get you closer to the screen originally, still couldn't hear you very well. And that made it kind of tough. Also a lot of reading notes, which is okay, but try not to make it as obvious like when you're reading. Other than that, you guys were great. Sorry, I came in with the criticism. Everyone else gave you guys a lot of compliments, so I felt the need to have to do the constructive criticism, but you guys really were great, and it was great watching you guys. So good job.
All right, guys, so Judge Adillo here. Hopefully not the last time I get to be called a judge, but I am a civil rights attorney in Chicago, and I echo the sentiments of all of the jurors. You guys did a fantastic job. I was impressed. I think you guys really handled everything well, particularly your experts. I thought both voir dires were appropriate. I thought the objections surrounding the experts were really sound. And I think you guys did a great job of that, considering this is Battle of the Experts. You guys are right on point. To give you each side a point of criticism. For the defense, I thought your objection to the experts, specifically Kylie, that malingering in the DSM-5, I thought that was a creative argument to then voir dire the expert on. And then I mentioned it to you, feel free to re-raise it if you find that this expert later on, once testimony comes out that, you know, doesn't seem like this person can talk about malingering. And the witness said, and I wrote it down, I'm not positive how many of these factors are required for malingering. That completely undermines the diagnosis. I was expecting you to fly out of your chair at that point and say, Your Honor, this is my point. This witness does not know. But I get it. Like, I used to do this too, the nerves, the jitters, and I thought you guys still handled objections well despite that. For the prosecution, during the cross, I believe of Riley, yes, that would be you, Ms. Golden. You talked about sentencing and the effects of sentencing, and I kind of alluded to this already. That's inappropriate in a criminal trial. Normally, sentencing is a completely different matter. And so, you know, for you to then talk about, and, you know, he might go to jail for this, and that could impact his ability to get a job. And that's not relevant. It's substantially prejudicial. And so I did expect defense to object. They did. It was just a little late. But otherwise, I'm still glad you caught it, because that means you're listening like an attorney. So overall, though, you guys did an excellent job. So now that the comments are all over, I was told that I should thank you all. So thank you everyone for being here today. Advocates, thank you for showing up, because you definitely did. You all are now permitted to log off Zoom. So have a great day.
Thank you.